This video is a case review on Wong Foh Hin against Public Prosecutor, prepared for Mr. Muhammad Firdaus Bidin and prepared by Fatin Dalila Hamdan, student ID 248110. The fact of the case is as such. The appellant had killed his own daughter. On that day, the appellant had asked his daughter twice to leave the house. Later on, he asked his daughter to massage him. The appellant had sent his two other children to his wife. The appellant was on his bed with his daughter. After a while, the wife heard the daughter call out. Apparently, she was in pain. When the wife went to the room, she found the bed was moving and saw the appellant pulling on his trouser. The appellant said that he was going outside to defecate and asked the daughter to go with him. When the wife went away, the appellant had stayed in the room and shut the door. The wife had reported to the police. When the police and the wife returned to the house, the daughter was not found and the appellant was took by the police. 2 days later, the daughter's body was found in a well near the house. 3 months before the incident, the wife had made a complaint to the orang tua, which is the village headman. This is whereby the wife said the appellant had interfered with the daughter. This matter had been disposed by the orang tua that if it were to occur again, the matter would be reported to the police. The wife implied that the daughter and the appellant had an incestuous relationship. The appellant, the wife, and the orang tua had signed a document which was produced in evidence, recording the allegation and the warning of reporting to the police if it occurred again. The issue of this case is whether the evidence of incestuous relationship between the appellant and the daughter submitted to the court is admissible as it shows bad character evidence. In this case, the court held the appeal made was dismissed and the conviction and sentence was confirmed. The judge in this case held the bad character evidence was on the allegation or evidence of the incident on May, whereby the wife reported to the orang tua of the appellant interfering with the daughter. It was implied that they had an incestuous relationship. A warning was given by the orang tua that if this was to happen again, he would make a report to the police. Referring to the case of MLJ against Attorney General of New South Wales, it was undoubtedly not competent for the prosecution to adduce evidence tending to show that the accused had been guilty of criminal acts other than those covered by the indictment. For the purpose of leading the conclusion that the accused is a person likely from the criminal conduct or character to have committed the offence which he is being tried. On the other hand, the mere fact that the evidence adduced tend to show the commission of other crimes does not render it inadmissible, if it be relevant to an issue before the jury. It was also adduced that the evidence complained of in this case came within the first proposition set out in this passage. The second proposition did not apply to it, and therefore the evidence is inadmissible. The evidence of incestuous relationship is admissible within the second proposition. There are two parts of the proposition. The first part is on the effect of the evidence which is otherwise admissible is not rendered inadmissible merely because it tends to show the commission of other offences. The second part is on the judicial committee in the appeal, specifically the evidence tending to show design or system rebutting a possible defence of accident. Evidence, if otherwise admissible, is not rendered inadmissible merely because it tends to show bad character or the commission of other offences. In this case, the evidence being objected has the strongest possible evidence of motive. This applies to the evidence of both incidents. The evidence concerning the orang tua shows how strong the motive must have been for the wife to went off in the night on the second occasion. The appellant might be concerned that this time a police would come to investigate and the most important person the police would interview would be the daughter. Section 8 of the Evidence Ordinance or Evidence Act stated that any fact is relevant which shows or constitutes a motive or preparation for any fact in issue or relevant fact. Section 54 of Evidence Act mentioned on the evidence of character. This is whereby it stated that in criminal proceedings, the fact that the accused person has a bad character is irrelevant unless evidence has been given that he has a good character in which it becomes relevant. Evidence was admissible. Strong and convincing evidence of motive will probably have a high value in all circumstances. However, there must be especially so in a case like this, where there is only circumstantial evidence of the murder itself. In this case, the trial judge is correct in not exercising his discretion in favor of excluding the evidence on the ground of prejudicial effect would be out of proportion to its evidential view. What I've learned from this case is on the principles of bad character evidence. The general rule in Section 54(1) of Evidence Act as a shield to the accused whereby any evidence of his bad character is prevented from being tendered. Bad character evidence is used to make a general reference that the accused is likely to have committed the offence charged, which is too prejudicial toward the accused person. Really, this means bad character evidence cannot be tendered and is inadmissible, as it may be too prejudicial to the accused. However, the accused or his counsel can adduce evidence of his own previous misconduct without any restriction. The evidence of bad character of the accused is irrelevant and inadmissible, as the guilt of the accused must be proved by independent evidence and not on the basis of the character. However, Section 54(2) of the Evidence Act provides instances where the shield against bad character evidence of the accused can be broken. In Section 54(2)(a), it stated when there is proof that he has committed or been convicted of that other offences, it is admissible evidence to show that he is guilty of the offence wherewith he is then charged. Basically, this provision allows the accused to be asked about misconduct which has already been admitted in chief as part of the prosecution case, usually evidence related to similar fact evidence. Therefore, the accused in a criminal proceeding has a shield against cross-examination on his character, but risks losing this shield in circumstances provided under Section 54(2), subsection A, B, and C. Precondition to be met is that the accused must be called as a witness. Therefore, it can be concluded that where Section 54(1) of Evidence Act provide a shield for bad character evidence, whereby it provide protection for the accused from his previous misconduct or bad character to be used or tendered in court, Section 54(2), subsection A, B, C broke this shield with providing exception.